Well, it's a disgrace. But we just are determined in 3 more weeks. I thought they would finish today. And they aren't finished today. If you look at what's happening. I thought they were going to be finished today, and they won 2 to 3 more weeks. The judge asked it and play right into the judge's hands. The judge is so happy about doing 3 more weeks because they all want to keep you off the campaign trail. That's all this is about. This is about election interference. How do we stop?
The day started and ended at Donald Trump's criminal trial, week 4, day 12, with Donald Trump's lawyers whining to Justice Merchan that they are not prepared to examine certain witnesses. At the end of the proceedings, they said that they are being sandbagged and that the proceedings are so unfair because the district attorney's office was not giving them in advance the list of when each witness would go. The district attorney's office says, look, you have our witness list, so you know the witnesses we're going to call. We're just not going to give you advance notice of when we're calling each specific witness, because when Donald Trump started threatening and attacking witnesses, we then reserved our right, which we are now acting upon, not to give Donald Trump the witness information. We don't have to give him this information. We can withhold it. And because of the threats he posed to the witnesses, we're just not going to give you their order. But you should be prepared for these witnesses because they work for you. Most of them work for the Trump organization. Take today's witnesses who the defense lawyers were complaining they didn't have advance notice of. These are people who have spent their careers working at the Trump organization. You had Jeffrey McConney, who was the longtime controller at the Trump organization. McConney worked at the Trump organization for about 40 years. How do you not know what to question Jeffrey McConney of when he was your controller at the Trump organization? These are your documents. These people worked for the Trump organization. Then after McConney testified, you had Deborah Tarasoff testify, and she was the accounts payable supervisor. Again, she's worked at the Trump organization for her career. She was the one who Alan Weisselberg or McConney or Trump would ultimately tell to cut the checks to whoever the recipients are. She was aware of the protocols, and anything above $10,000, Deborah Tarasoff stated that it required the approval. Any accounts payable that she would be making that was above $10,000, she needed the approval of either Eric Trump, Don Jr., or Donald Trump. And if Donald Trump was going to sign the check, he had to approve it. He micromanaged all of the checks that were going out. It was run like a family business, she testified to. There are not all that many employees who really work at the Trump organization. So again, these are Trump organization employees. And again, the fact that defense counsel keeps on whining and whining that they are being sandbagged throughout the proceeding, it's clearly you get the lawyers you deserve here, or the lawyers who had decent reputations before taking this case have now taken on the persona of their client as just perpetual whiners and perpetual victims. Also, what went down today, we reported about this in another video, so I'm not going to go over it in much more detail here. After Donald Trump's lawyer started complaining early in the morning, Donald Trump was found in contempt, criminal contempt, for his 10th violation of the gag order. Justice Merchan looked at Donald Trump and said, any more violations, you are going to jail. I have no option but to send you to jail. You are not following the instructions and orders of the court. We have to preserve law and order here. So listen very carefully. The next time you do that, I am putting you in jail. I don't care who you are. I don't care what positions you've held in the past. You do it again, you're going to jail, Mr. Trump. Do you understand me? So that's how the day kicked off. Great way to kick it off. And then you had Jeff McConney testify. And look, while maybe it wasn't as dramatic as the testimony of Hope Hicks or Keith Davidson or David Pecker's testimony from last week, this is a document case. This is a falsification of business case. And look, McConney kept contemporaneous notes. Alan Weisselberg kept contemporaneous notes, so we can actually see how the falsification of business records actually went down. We are now in the cover-up phase of this criminal trial, right? The first 3 weeks, we were on the Trump trying to interfere with the 2016 election phase, make the hush money payments, how he engaged in catch and kill. Now we're on the falsification of business records phase, the cover-up, how it went down. So take a look. This is something that Jeff McConney testified to. He authenticated these records. You can see right here, this is handwritten notations by ex-Trump Organization CFO Alan Weisselberg, and these notes were to McConney. And you see right here, if you look at the bottom, you'll see that it says $180,000, which was the $130,000 payment to Stormy Daniels, plus $50,000 paid to something called Red Finch, that Michael Cohen paid $130,000 to Stormy, $50,000 to Red Finch, which was like an online polling company to try to manipulate their polls in the 2016 election. McConney didn't know what Red Finch is. We know what Red Finch is here. We reported on that scheme before. Then you'll see, as part of the notations, it talks about grossed up to $360,000. So $180,000, gross it up to $360,000 when you reimburse Cohen, so he doesn't have to pay. So when he has to pay taxes, he's reimbursed for the amount that he went out of pocket, and then there is an additional bonus that's paid to Cohen. So there's a bonus to Cohen, and then there's the $180,000, $130,000 to Stormy Daniels, and this is in the notations, and McConney talked about that. This was another handwritten note in a separate document backing up all those other notations, as Adam Klasfeld reports. Jeff McConney jotting down the same system on Trump Organization letterhead, the amount of money to be paid to Michael Cohen for reimbursement. There was a moment during cross-examination of McConney, the controller, where Donald Trump's lawyer, Emil Bove, was cross-examining McConney, and McConney directly undercut Trump's whole defense. He goes, no, that was reimbursement. It wasn't for services rendered. We knew we were reimbursing Cohen for money that he had previously paid. So that was very important. And then you had the testimony of Deborah Tarasoff from Accounts Payable. Tarasoff says she's still currently employed by the Trump Organization. So y'all complaining about being sandbagged by someone who works for your organization right now. Christopher Conroy for the prosecution was questioning her, and the prosecutors have said that Trump signed 9 of the reimbursement checks to Cohen. And then Tarasoff talked about how, look, Donald Trump would frequently void checks. The checks would be clipped to the invoice. They'd be sent to Trump. Trump would look at it. Trump would either ask that they be negotiated down. He would void them if he didn't want to pay it, or he would sign it, or he'd have somebody else sign it. But he looked at these invoices. And so what the prosecution pointed out using Tarasoff is that they went through each of the checks. They showed that Donald Trump would look at the checks. Donald Trump saw what they were for. Trump would approve, and he would sign off on them. And so, Tarasoff's testimony, I think, was very helpful. As Karen Friedman-Agnifilo said, look, this is a document-based case, and that she expected exactly what we saw today. Go over the invoices, go over the corroborating evidence, go over all of the data that corroborates ultimately what Michael Cohen's going to testify to. And by the time Michael Cohen actually will be testifying, all of the documents that everybody else within the Trump Organization, within the campaign, David Pecker, Keith Davidson, everything that Cohen says is corroborated by all of these people. So again, we have Trump whining about being sandbagged, how unfair it is. Trump's lawyers whining, saying it's so unfair. Look, I think Trump knew the way this was going to go down. So earlier in the day, he came out with that stack of articles that he has people print out for him, and he was saying, look, it's so unfair. All of these witnesses are so unfair.
And absolutely no case. It's a political hoax. It's election interference. Anything they can do. And even the witnesses they want to bring up, they have nothing to do with the case. This is a ridiculous situation. Not there, but we will like.
In any event, it was his witness. These people worked at the Trump Organization. So there you have it. The conclusion of day 12, week 4 of the Trump criminal trial. We'll keep you posted as we learn more. But another objectively bad day for Donald Trump. I don't just go, oh, it's a bad day for Trump. With Judge Michael Luttig.
We had him on as a special interview. Couldn't think of a better person to speak to our audience at this critical and pivotal moment than former appellate judge, federal judge, constitutional scholar, iconic firebrand Michael Ludick. And we talked on our most recent interview exclusively on the Midas Touch Network about why the United States Supreme Court in its majority did not talk about Donald Trump almost at all during the oral argument. Why was his indictment not raised? Why did they focus on hypotheticals and abstracts and things that wouldn't bog them down with those nasty little things we call facts about what Donald Trump is indicted for in the criminal indictment against him? What does that mean for the eventual decision by the United States Supreme Court? Judge Ludick and I discuss it right here. That I don't know, it was almost like, well, we don't, you were encouraging the court, and obviously the right wing of the court did not take up the invitation that you gave, which is the proper constitutional approach. You've got an indictment here about a president at the time that tried to cling to power and tried to prevent and get himself a second term. That goes to core issues in the Constitution. Your entire brief was about that, was about this particular set of crimes that have been charged could never be immune. And then you gave all the reasons over 50 pages why that was the case. How frustrated were you to listen to 2.5 hours and not have that issue come up at all? I'll preface it this way. Instead, as I've told our listeners and followers, to give them a little bit of a decoder ring, when you hear justices, and unfortunately it's usually on the right wing, say things like, I don't want to talk about the facts of this case. Let's talk about it in the abstract. I don't care about this particular indictment. I care about legacy and future. And that's paraphrasing Alito, Kavanaugh, Gorsuch, and by extension, Roberts. When you hear that, you're going to hear judicial activism having nothing to do with the case and lawmaking. This is my view. You can tell me whether you agree or not. And lawmaking that is inconsistent with constitutional principles.
Michael, it was remarkable and astonishing. Now, I should say that it was reminiscent of the argument by the court in the Trump versus Anderson case, which presented the question of whether the former president is disqualified under Section 3 of the 14th Amendment for having engaged in an insurrection or rebellion against the Constitution of the United States. There, as you'll recall, and as your viewers and listeners will recall, there too, the Supreme Court barely discussed at all that issue. It was evident from the argument, by the time of the end of the argument, that the Supreme Court was never going to decide the issue. Not then, not ever. And of course, it didn't. So also with this argument this week on another of the most profound constitutional issues possible under our Constitution of the United States. The Supreme Court barely addressed the issue itself. It would be virtually unheard of for the court, in light of that argument, to decide the case. No one believes it's going to. I don't. It seemed evident from the court that it will remand the case back to the district court, federal district court, to determine in the first instance which acts of the former president were taken in his official capacity as President of the United States, which were taken in his private or personal capacity, and presumably which were taken in his capacity as a candidate for the presidency of the United States. Michael, those are quintessential issues for the Supreme Court of the United States of America. The Supreme Court sits for the purpose of deciding those fundamental questions. And it could decide those questions today. There's not a reason in the world to remand this case to the lower courts. If it does so, there's no question whatsoever but that the former president will not be tried before the election in November, but it's exceedingly unlikely that he will ever be tried and held accountable for the grave offenses against the United States that he committed in or around January 6, 2021.
And Judge, if they do that, if the 5 votes or even 6 votes vote to send it back to Judge Chutkan, are they doing it on purpose in order to help this former president in his election bid?
Well, I'm not going to ascribe a motive to them, Michael, but I will state the facts that it's completely unnecessary for them to do so. And if they were to do so, they would know that the consequence of that is that the former president would not be tried before the election and possibly never tried.